All right. Well, thank you all so much for joining us for tonight's program, The Trial of Susan B. Anthony, Voting Rights for Women. In 1873, Susan B. Anthony was indicted by a grand jury for, quote, knowingly, wrongfully, and unlawfully voting. The said Susan B. Anthony being then and there a person of the female sex, close quote. So her trial, in which Anthony was convicted of breaking the law by casting a vote in a presidential election, became one of the most famous trials of the 19th century. Far from defeating the fledgling movement for women's suffrage, the trial brought more publicity to the issue, largely due to Anthony's clever strategy of publishing the trial proceedings and then shrewdly using it for a PR campaign to rally women to the cause. And tonight's talk is led by the Honorable Dennis J. Curran, who's a retired Massachusetts Superior Court Justice, and he has taught law at Tufts University, Roger Williams University School of Law, and Brown University. And I again want to thank the Friends of the Library for sponsoring. So all 150 plus folks who are watching live and the many more that will watch the recording, let's give a big virtual round of applause to Dennis for joining us tonight. And Dennis, you can take it away. Thanks so much.
Thank you, Robert. Good evening, all, and welcome. It was almost 104 years ago that the first woman legally cast her vote for President of the United States. What led to that remarkable day? Well, a tremendous amount of hard work and sacrifice. We begin our story this evening with images reminding us of the tenor of those times. Now, if you'll notice, one of the interesting things that I found historically, the photo on the left with the women in black indicates photos taken in the 19th century, that is the 1800s. And then the women's suffragettes movement moved to white in the right-hand photo on the right-hand side. Suffragettes faced derision, as you'll see from these cartoons at the time. Down with the men, no men allowed. They kick a man out of a meeting. Suffragettes on the warpath, jump on him. He is only a mere man. That's a police officer, actually. And how about this one? Taking it out on hubby. I tell you, we will have the vote, you big, massive brute. Doesn't quite look like a big, massive brute there on the left. Yes, yes, and yes. And then on the right, down with the men and up with the women. These are the cartoons of the time. And this one was particularly poignant. Did I save my country for this? Says Washington. These are the altercations that women who were seeking the suffrage were suffered. In the end, the democratic process worked as it should, but it was a difficult and decades-long struggle. Starting out with the Seneca Falls Convention in 1848, and this is one of the later photos. As you can see, the women are dressed in black from the 19th century. Deeds, not words, were the watchwords of that particular convention. Contrary to popular myth, Susan B. Anthony, the famous suffragette on whom we're going to focus tonight, and Elizabeth Cady Stanton did not meet in 1848 at the first convention. Susan B. Anthony did not attend one. The historical fact is that they met at the second convention in 1852. And here's an example of what the women were up against. Headquarters, the National Association of Folks that are opposed to women's suffrage. And interestingly, the men all have their backs to the camera. I doubt they dared show their faces because they would get probably hell at home. Just my speculation. With the passage of a century, we tend to forget the fierce political battle between the sexes to give women the right to vote. Before we address the substance of that struggle, I thought I'd share with you a lighter and nonetheless accurate look at the way the differences between the sexes were portrayed not that long ago, when some of us were just kids.
The meeting is now in order. We all know that the McGillicuddy girls gave a party the other day, and not one of us was invited. Now, what do you say if we form a new club and call it the He-Men Woman Haters Club? Now, I think we ought to have a president. Now, the man we elect must be the worst woman hater of us all. So I nominate Alfalfa because he hates women. To Darla from Alfalfa. Yeah, Alfalfa. What do you want? Bank wants you at a bond. What for? I don't know. Only Jiz in boarding. Ginny boarding. Yes. Oh, all right. Say, fellows, will you do me a favor? Yes. Take this note and give it to Darla. Understand? Mm-hmm. Mm-hmm. And keep it under your hat. Get me? Mm-hmm. Mm-hmm. Okay. Up there. Oh, door. Someone working this door. Frankie, what's this all about? Alfalfa, we've just formed a new club and elected you president. In the first place, what shall I say? Tell them about the rules. First of all, the rules of this club must be obeyed. Spike, come here. I now elect you Sergeant at Arms and present you with official paddle. Thanks, pal. And any man who breaks the rules of this club shall get 5 swats from my pal. And I'm just the guy that can do it, too. By the way, Spanky, what am I president of? Why, the He-Men Woman Haters Club. And what are the rules? No man is to be seen with girls. You can't look at them, you can't walk with them, you can't talk with them, and you can't even write letters to them. I say, Spanky, I just remembered. I got some important business to do. I'll be right back. Bye.
The first woman to vote for president of the United States wasn't 104 years ago. It was cast in November 1872 by Susan B. Anthony in a courageous effort to test the United States Constitution to exercise what she believed to be her right to the franchise. For her effort, Anthony was jailed and tried. In the end, her vote wasn't counted, but it did galvanize others to mobilize, organize, strategize, and eventually convince men to give women the right to vote nearly 50 years later. Here is how Susan B. Anthony saw the issue. It was we the people, not we the white male citizens, nor yet we the male citizens, but we the whole people who formed the Union. And we formed it not to give the blessings of liberty, but to secure them, not to the half of ourselves and the half of our posterity, prosperity, but to the whole people, women as well as men. Who was Susan B. Anthony? She was born actually in Massachusetts and became involved in social activism at the ripe age of 16, and later became a lifelong friend to Elizabeth Cady Stanton. Anthony believed in rights for married women. These are the rights that she was outspoken for. Believe it or not, the first right was the right to speak in a public setting, which women did not have in the 1850s, if you can believe it. Also believed in rights for married women, and finally, the right to vote. When Susan B. Anthony, at age 32, attended her first women's rights convention in Syracuse, New York, she declared that the right which women needed above every other was the right of suffrage. If you think about it, without the right of suffrage, you have no other rights because you can't control or have a say in what's going to go on. Anthony spent the next 50 years of her life fighting for the right to vote. She worked tirelessly. And that's actually an image from the second women's rights convention in 1852 that she attended as her first. She gave speeches, she petitioned Congress and state legislatures. And let me divert for a moment. The sketch on the left-hand side is actually an original sketch of that conference in 1852. The one on the right-hand side was drawn many years later, but the one on the left-hand side is historically accurate. Anthony published a feminist newspaper called The Revolution. Oh, by the way, this is her on the stump on the right-hand side, and this is an 1882 lecture, 1882 or 3 lecture in December 28th of that year. And here is the newspaper or the broadside that Anthony published, all for a cause that would not succeed until the ratification of the 19th Amendment 14 years after her death. And here's the masthead of the Revolution. What therefore God hath joined together, let not man put asunder. This issue is dated in 1870. What's that amendment? Well, the rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. And that's what led to the first legitimate vote for President of the United States or any federal office in November of 1920. Now, Anthony would have the satisfaction of her vote drop into a ballot box. And so let's start from the beginning. Our story starts in Rochester, New York on November 5th, 1872, which was presidential election day. And the event and the trial for illegal voting that followed created an opportunity for Anthony to spread her arguments for women's suffrage to a wider audience than had ever before happened. Anthony had actually been planning to vote long before 1872. She had taken the legal position and argued it wherever she could that the recently adopted 14th Amendment gave women the constitutional right to vote in federal elections. So let's look at that 14th Amendment, particularly one. All persons born and naturalized in the United States are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, at first glance, you say to yourself, well, all persons born are citizens of the United States. and no state shall abridge the privileges of immunities of citizens of the United States. Well, believe it or not, women were not considered citizens, if you can believe that. The amendment said that all persons born are citizens of the United States, but women were not citizens. So, in any event, when Anthony saw this language, to her way of thinking, those privileges included the right to vote. The problem, however, was that Susan Anthony and her supporters failed to read, or probably chose to ignore, Section 2 of that same amendment, which said, when the right to vote at any election is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States are in any way abridged. You see that? Male inhabitants. And furthermore, she ignored the clear language of the 15th Amendment. These are all what we call the civil rights laws enacted directly after the Civil War, which were aimed at Black civil rights. And here's the 15th Amendment, Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of what? Race, color, or previous condition of servitude, meaning slavery. Now, what's missing among those words, race, color, or previous condition of servitude? As you can see, there is no mention whatsoever in either amendment of extending the franchise to women. No mention of sex in the 15th Amendment, and in fact, the 14th Amendment refers specifically once to, remember, male inhabitants, and twice to a male citizen in the same paragraph regarding the right to vote. That's just the way it was. I didn't write these words. That's what the drafters of those amendments wrote and obviously meant. But one lawyer who was married to a suffragette thought that the language of Section 1 of the 14th Amendment could be interpreted as allowing the women to vote. And that was all Susan B. Anthony and Elizabeth Cady Stanton needed to hear. They published that lawyer's analysis in their newspaper, The Revolution, and urged women to vote. And when denied the right to vote, they intended to sue. On November 1st, 1872, Anthony and her 3 sisters entered a voter registration office set up in a, of all places, a barbershop. What image does that give to you? Women were not allowed to go into a barbershop. That was a male bastion in those days. They were part of a group of 50 women that Anthony had organized to register to vote in her hometown of Rochester, New York. When the women entered the barbershop, the women saw 3 young men serving as election registrars stationed in the office. Anthony walked directly to the registrars, and as one of them later testified, demanded that we register them as voters. They refused Anthony's request, but she persisted, quoting the 14th Amendment citizenship provision and the article from the New York State Constitution pertaining to voting, which contained no sex disqualification. The registrars were unconvinced. And finally, according to one account, Anthony gave the men an argument that she thought might get their attention. If you refuse us, our rights as citizens, I'll bring charges against you in criminal court, and I'll sue each of you personally for large damages. And then adding, I know I can win. I have Judge Selden as the lawyer. He's a retired judge, by the way. There is no shortage of money to back me up. Registrars were stunned. They sought the advice of the supervisor of elections, who told them that they should allow the women to take the oath of registry. He told them, young men, you know the penalty of law if you refuse to register these names? Registering the women, he advised, would put the entire onus of the affair on them. And in all, 14 Rochester women successfully registered to vote that day, leading to calls in one newspaper for the arrest of the voting registrars who complied with the women's demand. One newspaper editorialized, "Citizenship no more carries the right to vote than it carries the power to fly to the moon." Little wouldn't they know about 100 years plus that we would be on the moon. If these women offer to vote, they should be challenged, and if they take their oaths and the inspectors receive and deposit their ballots, they should all be prosecuted to the full extent of the law. Soon after the polls opened for the presidential election of 1872, Anthony and 7 or 8 other women cast their ballots. The election registrars voted 2-1 to accept Anthony's vote, and her folded ballot was deposited in a ballot box. One of the registrars later testified as to feeling caught between a rock and a hard place. Decide which way we must, we were liable to prosecution. We were expected to make an infallible decision inside of 2 days of a question in which some of the best minds of the country are divided. 7 or 8 more women of Rochester successfully voted that afternoon. Anthony's vote went to elect President Ulysses S. Grant and other Republicans based on that party's promise to give the demands of women a respectful hearing. Not necessarily to give them the vote, but just to give them a hearing. By contrast, the Democrats wouldn't even give them a hearing. Later that day, Anthony wrote of her accomplishment to her close friend and fellow suffragette, Aunt Elizabeth Cady Stanton. And look at that cartoon, not cartoon, that sketch, the female agitators. All right, so here's the letter Anthony wrote to Stanton. "Well, I've been and gone and done it. Positively voted the Republican ticket straight this AM at 7 o'clock. The Democratic paper is out against us strong, and that scared the Dems on the registry board. How I wish you were there. All the suffrage women would work to this end of enforcing the existing Constitution, supremacy of national law over state law. What strides we might make this winter. So, all right, I hope you voted too. Affectionately, Susan B. Anthony." I actually think that Cady Stanton did not vote, whatever reason. In any event, a controversy ensued. Susan B. Anthony's vote was a major topic in the days that followed. A Democratic poll watcher filed a complaint charging Anthony with casting an illegal vote, challenging Anthony's both her registration and her subsequent vote. And a United States commissioner, who's now comparable to what we would call a United States magistrate, issued a warrant for Anthony's arrest. The warrant charged Anthony with voting in a federal election, quote, "without having a lawful right to vote and in violation of the Enforcement Act," which was enacted by Congress in 1870. The law carried a maximum penalty of $500 or 3 years in prison. Anthony's arrest, however, was delayed for 4 days to allow time for the United States commissioners to meet and discuss the case. They weren't sure whether prosecution should go forward. Discuss the case with prosecutors in the United States District Attorney's Office for New York. Now, we now call the United States District Attorney simply the United States Attorney, but it was called the United States District Attorney in those days. And the United States Deputy Marshal eventually showed up at Anthony's home and arrested her. When she arrived at the jail, Anthony was surprised to learn that among those arrested for their activities were not only the 14 other women voters, but also the election registrars who had authorized their votes. They were all in the same jail cell. Anthony's lawyers refused to enter a plea at the time of her arrest, and the United States Commissioner scheduled a preliminary examination. Anthony was questioned at the hearing by one of her lawyers who tried to establish that Anthony believed in good faith that she had a legitimate right to vote and therefore had not violated the 1870 Enforcement Act, which prohibited only willful and knowing illegal votes. Anthony testified that she had sought legal advice from an attorney before she cast her vote, but also admitted that he told her, quote, he had not studied the question. Anthony was asked, do you have any doubt yourself of your right to vote? And she replied, not a particle. They postponed her case. Now, after listening to legal arguments, the commissioner concluded that Anthony probably had violated the law. When Anthony, alone among those charged with election day offenses, refused to pay her bail, she was ordered held in the custody of a deputy marshal until the grand jury had a chance to meet and consider issuing an indictment. Anthony saw the commissioner's decision as a ticket for her case to zoom up to the United States Supreme Court for review, and she began making plans with her lawyers to file for a petition for a writ of habeas corpus. And not surprisingly, Anthony was already out trying to make political hay, not out of the jail, but out there politically trying to make political hay out of her arrest. She sent off hundreds of papers concerning her arrest to suffragette friends and politicians. Anthony's attorney asked a United States District Court judge to issue a writ of habeas corpus ordering that Anthony be released. But the judge denied it. Instead, he raised her bail from $500 to $1,000. Anthony again refused to pay. Her own lawyer, though, decided to pay her bill. And in doing so, he forfeited Anthony's chance to get her case before the United States Supreme Court. When she had heard what her male lawyer had done, she confronted him, demanding that he explain himself. She didn't want bail to be posted. The lawyer responded, I could not see a lady I respected put in jail. A disappointed Anthony still had a trial to face. A grand jury of 20 men returned an indictment against Anthony, charging her with knowingly, wrongfully, and unlawfully voting without having a lawful right to do so, the said Susan B. Anthony being then and there a person of the female sex. And here is a copy of the actual indictment. Now, obviously, no one had ever been charged, so if you look in the very middle of it, it's very difficult to read, but it says, without having a lawful right to vote in said first election district, and then they had to add this in handwriting, it said Susan B. Anthony being then and there a person of female sex. Goodness gracious. And then they had to add as she, the said Susan B. Anthony, because no women had ever been charged. The trial was set. Anthony used the next 4 months before her trial to educate the citizens of Rochester and surrounding counties on the issue of women's suffrage. She took to the stump, speaking in town after town, repeatedly posing this question to the crowds. Is it a crime for a citizen of the United States to vote? I don't think you could actually size up and put the issue in a more poignant context than that simple sentence. How succinct and compelling. Anthony's exhausting lecture tour had taken to every one of the 29 districts in the New York counties. And to many in her audience, Anthony was the picture of, quote, sophisticated refinement and sincerity, end quote. The 52-year-old suffragette would look at her audience, ranging from a few dozen to over 100 persons, and begin, friends, and fellow citizens. I stand before you tonight under indictment for the alleged crime of having voted at the last presidential election without having a lawful right to vote. It shall be my work this evening to prove to you that in thus voting, I not only committed no crime, but instead simply exercised my citizen's right guaranteed to me and all United States citizens by the national Constitution, beyond the power of any state to deny. And in her speeches, she quoted the Declaration of Independence, the United States Constitution, the New York Constitution, James Madison, Thomas Paine, the United States Supreme Court, and several of the leading radical Republican senators of the day to support her contention that women had the legal right as citizens to vote. She argued also that natural law, as well as a proper interpretation of the Civil War amendments, gave women the power to vote. Her lecture tour began to worry her prosecutor. And in a letter to Senator Benjamin F. Butler of Massachusetts, Anthony wrote, "I've just now canvassed this county," the county in which she was going to be tried, "from which my jurors are to be drawn. And I rather guess the United States District Attorney, who is very bitter, will hardly find 12 men so ignorant on the citizens' rights as to agree on a verdict of guilty." The prosecutor convinced the federal trial judge, who had recently, by the way, been appointed a justice to the United States Supreme Court, but was awaiting taking his oath of office. That particular judge was going to hear Anthony's case. He was not in the Supreme Court. He was a state judge in New York. The position of the prosecutor was that Anthony had prejudiced for all the potential jurors of the county. And so the judge agreed to move the trial to another county and reschedule the trial. But Anthony responded to the judge's move by immediately launching another lecture tour in that new county, the one to which the case was removed. She spoke for 21 days in a row, and concluded her tour the very night before the trial in the town where the trial was to be held the next morning. Many observers were skeptical about the strength of Anthony's case. A New York Times editorial, for example, opined, "Miss Anthony is not in the remotest degree likely to gain her case, nor if it were ever so desirable that women should vote, would hers be a good case. When so important a change in our Constitution as she proposes is made, it'll be done openly and unmistakably, and not left to the subtle interpretation of a clause adopted for a wholly different purpose." And here is how one suffragette saw the trial. Susan B. Anthony is not on trial. The United States is on trial. At trial, the prosecutor made the following opening statement. We think, on the part of the government, there is no question that whatever her intentions may have been, whether they were good or otherwise, she didn't have the right to vote. And if she did vote without having a lawful right to vote, then there's no question but that she is guilty of violating a law of the United States. For her part, the defense argued that Anthony reasonably believed that she was entitled to vote, and therefore could not be found guilty of the crime of knowingly casting an illegal vote. To support her argument, Anthony's defense attorneys called himself as a witness and testified, quote, "Before the last election, Miss Anthony called upon me for advice upon the question of whether she was or was not a legal voter. I examined the question and gave her my opinion unhesitatingly that the laws and the Constitution of the United States authorized her to vote, as well as they authorized any man to vote. The defense attorney tried to call Anthony as a witness so that she might testify to her state of mind when she voted. The district attorney objected. Quote, she is not a competent witness on her own behalf. Now, you have to realize that in 1872, all the way up until the mid-1890s, no criminal defendant in the United States, listen to this, no criminal defendant in the United States had the right to testify in his or her own behalf in their own defense in a criminal trial. Let me repeat that. No criminal defendant had the right to testify in their own behalf at their own criminal case at trial. And let's talk about the denial of that right for a moment. For centuries in both England and America, parties to litigation in both criminal and civil cases were disqualified by law from testifying in their own behalf. Only disinterested or neutral witnesses were permitted to testify, because in those days it was believed that if you were charged with a crime, you had a personal interest in the case and believed, listen to this, and would inevitably lie. Personal interest was thought to be so strong that it would overpower even the obligations of an oath, and swearing to tell the truth would not remove that disqualification. So, when a defendant was brought to trial in the 1700s or 1800s America, no criminal defendant had ever advanced the novel claim in any American case that he or she had the right to testify in their own defense. And none would do so until well after the Civil War, when the right to testify would gain recognition, mainly as a result of legislation. And the first state to do so, believe it or not, was the state of Maine. Now, although a defendant had no right to give sworn testimony, he or she did have the right to make an unsworn statement in open court, but only after the jury had found him or her guilty. All right. The only right to speak to the judge and the jury, it was called the right of allocution, and has long been traditional in criminal prosecutions in both England and America, and was given, and the right to give it was only after the judge asked if he or she had anything to say before sentence was pronounced. The defendant could say his or her piece, and what he or she said was not subject to cross-examination. Now, returning to the Susan B. Anthony trial, the judge barred Susan B. Anthony from taking the witness stand. The defense attorney opens his 3-hour-long argument by Anthony by stressing 3 points. First, that she was being prosecuted solely because of her gender. And here's what he said in that regard. I thought it's kind of an interesting argument. If the same act had been done by her brother, under the same circumstances, the act not only would have been innocent, but honorable and laudable. But having been done by a woman, it is said to be a crime. The crime, therefore, consists not in the act done, but in the simple fact that the person doing it was a woman and not a man. I believe this is the first instance in which a woman has been arraigned in a criminal court merely on account of her sex. And it's true. Second, he argued that Anthony's vote was legal because of the recently enacted 14th Amendment, saying, by the 14th Amendment, anyway, let me get back to that. His argument was, by the 14th Amendment, the United States had not only declared what constitutes citizenship, both in the United States and the several states, but have absolutely prohibited those states from making or enforcing any law which shall abridge the privileges and immunities of citizens of the United States. By virtue of this provision, I insist that the act of Susan B. Anthony in voting was lawful. And finally, third, he insisted that even if the 14th Amendment didn't make Anthony's vote quote, legal, she could not be prosecuted because she had acted in the good faith belief that her vote was legal. The defense attorney argued in his closing argument for 2 hours. And right after he finished, the judge took a piece of paper from his pocket that he had already written. Trial had just concluded seconds before, and he began reading his decision. Quote, the 14th Amendment gives no right to women, to a woman to vote, and the voting by Miss Anthony was in violation of the law. The judge rejected Anthony's argument that she had acted in good faith, saying, assuming that Miss Anthony believes she had a right to vote, the fact constitutes no defense. If in truth she didn't have the right, she voluntarily gave a right which was illegal and thus subject to the penalty of the law. And the judge then surprised Anthony and her attorney by directing a verdict of guilt. Upon this evidence, the judge said, I suppose there is no question for the jury. So the jury didn't even get a chance to decide the case, and that the jury should be directed or ordered to find a verdict of guilty. He essentially took the case away from the jury, which was a highly unusual development. In fact, in 40 plus whatever years of practicing law, I don't know, many years, I have never even heard of such a thing. And in her diary that night, Anthony angrily described the trial as the, quote, greatest judicial outrage history has ever recorded. We were convicted before we had a hearing, and the trial was a mere farce. Had the jurors had an opportunity to deliberate, it's entirely possible that Anthony might have not been convicted. A newspaper quoted one juror as saying, could I have spoken, I should have answered not guilty, and the men in the jury box would have sustained me. That was Anthony quoting one of the jurors. The next day, Anthony's defense attorney argued for a new trial on the ground that her constitutional right to a trial by jury had been violated. The judge promptly denied the motion. Before sentencing, the judge asked Susan B. Anthony, has the prisoner anything to say why sentence should not be pronounced? And that resulted in this colloquy, which we'll hear in just a moment with a few introductory words from this great video, I think.
Women had long been denied the right to vote, even after helping to win voting rights for blacks with the passage of the 15th Amendment. In November 1872, Susan B. Anthony was one of 14 women who defied the law to cast a ballot in the presidential election. Anthony was arrested for, quote, knowingly voting without having a lawful right to vote, unquote, and was found guilty.
Has the prisoner anything to say why sentence shall not be pronounced?
Yes, Your Honor, I have many things to say. Your denial of my citizens' right to vote is the denial of my right of consent as one of the governed, the denial of my right of representation as one of the taxed, the denial of my right to a trial by a jury of my peers as an offender against law. Therefore, the denial of my sacred right to life, liberty, property.
The court cannot allow the prisoner to go on.
But Your Honor will not deny me this one and only poor privilege of protest against this high-handed outrage upon my citizens' rights.
The sentence of the court is that you pay a fine of $100 and the costs of the prosecution.
May it please Your Honor, I will never pay $1 of your unjust penalty. All the stock in trade I possess is a debt of $10,000 incurred by publishing my paper, The Revolution, the sole object of which was to educate all women to do precisely as I have done. Rebel against your man-made, unjust, unconstitutional forms of law, which tax, fine, imprison, and hang women while denying them the right of representation in the government. and I will work on with might and main to pay every dollar of that honest debt, but not a penny shall go to this unjust claim, and I shall earnestly and persistently continue to urge all women to the practical recognition of the old revolutionary maxim, resistance to tyranny is obedience to God.
Well, Anthony thundered that the judge had trampled underfoot every vital principle of our government. My natural rights, my civil rights, my political rights, my judicial rights are all alike ignored. And the judge, in a move calculated to preclude any appeal to a higher court, ended the trial by announcing, "Madam, the court will not order you committed until the fine is paid." True to her word, Anthony never paid a penny of her fine. Her petition to Congress to remit the fine was never acted upon, but then again, the government really never made a serious effort to collect. Anthony tried to turn her trial and the conviction into political gains for the women's suffrage movement. She ordered 3,000 copies of the trial proceedings printed and distributed, and she sent them all to political activists, politicians, and libraries. And in the eyes of some, the trial had elevated Anthony to the status of martyr, while for others, the effect diminished her status to that of a common criminal. Many in the press saw Susan B. Anthony as the ultimate victor. As one New York newspaper, not the Times, observed, "If it is a mere question of who got the best of it, Miss Anthony is still ahead. She has voted, and the American Constitution has survived the shock." Fining her on $100 doesn't rule out the fact that women voted and then went home, and the world went on as before. Later in life, legal commentators said the trial was the greatest judicial outrage history has ever recorded. And what is the significance of this trial? Well, it contributed 3 ways to advance the principle of women's suffrage on social, legal, and constitutional grounds. The press coverage was enormous. There was a backlash against the trial judge for taking the case away from the jury and ordering the entry of a guilty verdict. And constitutionally, it obviously led to the ultimate adoption of the 19th Amendment. Our history in Massachusetts on this issue is not so commendable. In 1915, the issue of women's suffrage was on the ballot as a referendum to amend the state constitution. Now, this is before the federal 19th Amendment was enacted. Now, this is in Massachusetts. Let me repeat that. There was a referendum question in 1915 on the ballot to amend the state constitution to allow for women to vote. It failed miserably. And here are the election votes results. By the way, these are 2 campaign posters. "Show your faith in the women of Massachusetts. Vote yes on the amendment enabling women to vote." And then the no side, "The home-loving women do not want." Yeah, I wonder who drafted that. "Vote no on the amendment." All right, so here a yes vote would support the state constitutional amendment to provide women the right to vote. A no vote was to oppose the state constitutional amendment. And these are the vote results. Only 35% supported the women's suffrage in Massachusetts. Almost 65% voted against it. So, how do we honor the 50 years of sacrifice and tremendous legacy left by Susan B. Anthony? Well, it kind of reminds me of those T-shirts that kids get when their parents go for a vacation. And my parents went to Bermuda, and all I got was this T-shirt. Well, this is how they honor Susan B. Anthony, with a coin, reminding me my parents went to New York and all I got was this lousy t-shirt. I thought this was kind of cute. I may be your leader someday. This was done 80, 90 years ago or so. And boy, it's just proven true. And I also want to point out something that was done in 1835, written by Abraham Lincoln, who said, "I go for all sharing the privileges of government, who assist in bearing its burden, by no means excluding women." And finally, these are two excellent books on the trial of Susan B. Anthony. I also thank you as the audience members. And if you just need to email me, it's my email address on the upper left-hand corner. And then finally, I want to thank our folks at the library, and particularly Robert Hayes, and a special thank you, please, to the Friends of the Tewksbury Public Library who sponsored this evening's presentation. Thank you very much.
So folks, let's give Dennis a big virtual round of applause for a great presentation. I think my library might start looking like that photo you showed in about a month or so. So looking forward to that scene. So folks, we have at least 10 minutes or so for questions. If you have any questions, please get them into the Q&A. If you have any comments, please get those into the chat. Teresa says, "Thank you for such a fantastic presentation. Susan B. Anthony was beyond brave." Patricia says, "Thank you," as does Judy. Another Patricia says she loved this trial program. The presenter was awesome. Judy says, "A great program." And they've heard you, Dennis, at WWLL. I'm not sure what that stands for.
Wellesley Weston Lifetime Learning Program.
Oh, there you go. Barbara asks, "Do you know about voting rights for women in Europe? How did those come about? How does that compare to the US?"
I did research on this quite some time ago. I think they actually lagged behind the United States, with the possible exception of some of the Scandinavian countries, which were far more advanced in rights for women and still are to this day. The first female democratically elected head of state was of all places, in Iceland.
Bonnie says, "Well done." Let's see. Larry wants to know, do you happen to know who the first female was that was allowed to practice law?
No, but I'm open to suggestion. If you know, I'd be delighted to have. Oh, here we go. We have somebody coming in. I think it says Switzerland was the first one, and somebody had written it in onto chat. Do you see it?
Yeah, it looks like Switzerland I think Switzerland only gave women the right to vote in mid-20th century.
Yeah, that sounds about right.
Yeah. And then I think Arabella Mansfield, 1869, first female lawyer in the US admitted to the bar? Question mark. That seems to be my initial quick and dirty search results here.
Oh, good. Thank you, bro.
Okay, yeah. Let's see, anonymous attendees. So did states have laws that specifically prohibited women from voting prior to the amendment to the Constitution?
No, they didn't, but they didn't even say anything about women because they did not consider them citizens. They mirrored the federal Constitution. Although let's see, I do, excuse me, with one exception, excuse me. I wonder if any of you in the audience can guess which state all the other states were the same. Almost all the other states were the same. Which state first gave women the right to vote in its state elections, not federal elections, but state elections? Which state? Does anybody know? I'll tell you. Wyoming. I think the theory being that if you can haul water and graze cattle and do all the things that a farm person requires, I think you deserve the right to vote. That's my settlers very preliminary perspective on that. But
Yeah,
Wyoming was
a
the
few
right.
people, Dennis, in the chat guessed correctly.
Yeah. Oh, they did. Great.
Yep.
It's terrific.
So Eileen asks, to clarify, the trial judge was waiting to take the oath as a justice of the Supreme Court after telling the jury what to do.
Yeah. Can you believe it? It's just unfathomable to me. Never heard of it. I mean, and he went through to become a justice on the United States Supreme Court.
An anonymous
Don't ask me to
attendee
explain.
asks, so women weren't considered citizens at all when this happened?
Correct.
Or just for the purposes of voting?
At all. They didn't have any, no, they were not considered citizens. They had no rights. It was the husbands, all their rights reposed in their husbands.
Catherine wants to know, did Susan remain friends with all of her suffrage friends?
I don't know. I would hope. Well, she was extremely popular up until the time. I mean, she devoted her entire life, never married, never had a family, unlike Elizabeth Cady Stanton. So this was her life. I actually have some photos of her home office in the Rochester area in New Had and I didn't bring them up, but her office is, I've got to get out there because it's kind of cool. It's preserved as if she had just left her desk. The writing implement is on the desk and so forth. Quite a place. Yeah.
So if you can bottom line it here for us, Jackie wants to know, what did finally win women the right to vote?
I think a lot of women whispered in their husbands' ears because it was men who gave them the right to, I mean, who were the only ones who could grant it to them. And I think, and don't forget, we were entering into a somewhat progressive age, you know, for the times in the late 1910s, 1915, 1918, 1919.
Sharon asks, is the phrase directed verdict related to what happened to Anthony back in the day?
It's exactly what happened. That's exactly what happened. It was a directed verdict.
Are directed verdicts still used today sometimes?
Yes, they are. If a plaintiff, meaning a person or a corporation or whoever it is, bringing the claim has not made out the facts sufficient to arise to the status of the legal claim, the judge does have the authority to direct a verdict of a dismissal. It's very, very, very rarely done. As a matter of fact, in 450 cases, I never did it. Just never did it.
An anonymous attendee asks, why did Susan B. Anthony refer to herself as a citizen during the trial?
Because she thought in good faith that she only had to read Section 1 of the 14th Amendment. And a logical and common sense and 20th century version of that same argument is that she was perfectly reasonable in that. The problem is she didn't or chose not to read Section 2, which referred to the citizens as being male inhabitants. And she certainly didn't read or care to read the 15th Amendment, which granted the right to vote to blacks, but didn't mention women at all.
This is sort of a minor question, Dennis, but do you know who the actress was who was playing the part of Anthony?
Oh, I did know that. I did know that, and I've forgotten. Darn it.
Yeah, that's okay. The
I'm
attendee
so sorry.
you might have showed it, but the attendee couldn't read the name, so it's okay. We'll circle back on that.
The male, as you may know, is Josh Brolin. Jim Brolin, married to Barbara Streisand's son.
All right, so we're going to start to wind down. Callan in the chat notes that Wyoming's nickname is the equality state because of giving women the right to vote.
There you go.
Let's see. Jackie, very interested in this directed verdict thing here. wants to know, how is a directed verdict different from a verdict being set aside?
It's the same, it has the same effect, except that one occurs before the trial is over, meaning directed verdict is direct before the jury even gets the case, and the other is setting aside the verdict after the jury has announced its decision. So it's just a matter of timing, but the effect is the same.
All right. Last comment is going to Cindy. You know, and he gets beat up sometimes in our Q&As and in our chats. So we'll end on this. Cindy asks, any guesses on who gave an executive grant of clemency, a full pardon, posthumously to Susan B. Anthony for the conviction stemming from the only vote she ever cast in an election?
I knew that question. Oh, if I was on Trivial Pursuit, I do know the answer, but I've forgotten it.
That's
Help me out,
okay.
Cindy.
Well, so according to Cindy, it was President Donald J. Trump.
That's right. That's
About
right. That's right. I do remember that. Yeah, it was recent too. Yeah, obviously it was recent. That's right.
Yeah. So I think we've pretty much gone through every question or comment, at least the ones that I think I understand. So I think we'll wrap it there, Dennis. Do you have any last words for the audience, Dennis, before we wrap it up?
No, Robert, thank you very much for your kindly hosting and inviting me. And I do appreciate these opportunities to share this subject matter. And what do we have coming up in April, Robert?
Nuremberg trials.
What we have.
We have the Nuremberg trials in April.
Very good.
So
and that is an example, as you'll find, of the worst cross-examination ever conducted in human history.
All right. Well,
so bad at the Nuremberg trials that they use it as the basis of a course in many law schools.
Okay, well, we'll have to keep an eye out for that one. So information about that one will be in the email you all receive tomorrow, as well as the recording and a feedback survey. And then in May, Dennis, we're doing the Mississippi
burning trials.
Burning trials. Yeah,
right.
Yeah. And so anyway, we got a few more coming up. So keep an eye out for those, everyone. Thank you to the Friends of the Library. Thank you for our partnering libraries who help spread the word. And most of all, thank you to Dennis. Great job, Dennis, as always. And we'll see you back in about a month.
Very good. Thank you, Robert.
Right.
Good night,
Have
all.
a good night. Yep. Bye-bye.